Good morning. Welcome to our webinar on the new failure to prevent fraud offence. My name is Bill Dixon. This is Sarah Lonergan, and we are both lawyers at Field Seymour Parks. And this webinar, it's roughly going to be about 45 minutes. There should be some time, hopefully, for questions at the end. It is a live webinar, unless you're watching the recording, obviously. So we apologise in advance if you hit or we experience any technical difficulties. Obviously, we'll try to resolve those as quickly as we can, so do bear with us. And hopefully, everybody should be on mute. You should have an ability to answer questions or to raise questions if you'd like to do so. So do please feel free to do that as we go through our presentation. And from time to time, we will also ask you just to give us some feedback via polls. But I should emphasize on that your poll answers are all confidential. It's just a useful way to sort of generate a bit of feedback and gather in the sort of collective experience of everybody on some of these topics. The webinar is being recorded, and so you will be sent that after the presentation, together with a feedback form. And so if we could just move on to what we propose covering during the course of this presentation. Sarah is going to start just explaining a little bit about the Act, its background, when it comes into force, what sort of organisations are impacted, and she'll also explain the nature of the offence. And I will then go on to primarily dealing with prevention procedures and sanctions for breach. Over to you, Sarah.
Good morning, everybody, and welcome. So you ought to be able to see a poll on your screen. Bill's just mentioned, obviously, that they will be anonymous, but it's just something for us to have some of your feedback on. So poll you should be able to see is, has your organisation or one of its agents or suppliers ever been involved in allegations of fraud? So just give everybody a couple of seconds to answer that one. So it looks like there, so we can all see the results. So only a few, but obviously this isn't just a hot topic, and you've got obligations under the Act that we're going to be talking about. But it does occasionally happen, unfortunately. So moving on then, please. So what's the background to this Act that we're going to be talking about today? So the Economic Crime and Corporate Transparency Act 2003 has created a new offence designed at holding corporations to account for committing serious crimes, specifically the new failure to prevent fraud offence under Section 199. So government guidance for organisation on the offence for failure to prevent fraud was published in November 2024. And whilst it is advisory rather than binding, illustrates general principles for organisations in developing or enhancing procedures to prevent fraud and includes some examples of expected good practice. So the government guidance makes clear that an intended consequence of the new legislation will be to encourage more organisations to implement or improve prevention procedures, driving a major shift in corporate culture to help prevent fraud. So whilst the failure to prevent fraud is a new offence under the Act, this offence does still sit alongside existing legislation that you'll be familiar with and is already relevant to your various organisations. Moreover, this Act lends the types of fraud that will be caught under the new offence from existing legislation, such as fail to prevent the facilitation of tax evasion in the UK and overseas, and any expectations under the UK Corporate Governance Code. Therefore, this new offence should be considered by organisations to which it is applicable in the same way that organisations have regard to already embedded compliance with their anti-bribery, money laundering and preventing modern slavery obligations. So next slide, please. So when does this come into effect? So the offence will come into effect on the 1st September 2025, which the guidance states is to allow organisations time to develop and implement their fraud prevention procedures. So moving on. So what are the size of the organisations that are going to be affected by this offence? So the offence applies to large incorporated organisations, for example, bodies incorporated by the Companies Act, by Royal Charter, NHS trusts, and partnerships across all sectors of the economy, and applies across the UK. But what does the legislation define then as a large organisation? So section 201 of the Act states that an organisation meets this definition if the organisation has at least 2 out of the 3 following criteria. So more than 250 employees, more than 36 million annual turnover, and or more than £80 million in total assets. So these criteria apply to the whole organisation, including subsidiaries, regardless of where the organisation is headquartered or where its subsidiaries are located. If the organisation or subsidiaries are located outside of the UK, then in the event either a victim of the fraud is in the UK or the fraud was perpetrated in the UK, then a UK nexus is established and the offence will still apply. So naturally, there are various nuances and greater detail in the Act as to whether an organisation will be classified as a large organisation, and as a result, the government guidelines recommend obtaining legal advice on whether your organisation falls into the definition of a large organisation under the Act. So moving on, please. So why might this offence still be relevant to smaller organisations? So even if your organisation does not fall under the definition of a large organisation in the Act, do you still need to be concerned with the new offence? So as already identified, the intention of the new legislation and likely future legislation is to facilitate a greater shift in corporate culture to prevent fraud. Whilst a smaller organisation may not be found specifically liable under this offence, it will still benefit from adopting the recommended fraud prevention procedures aimed at reducing the likelihood of fraud being perpetrated within their organisation. Not only does this obviously constitute good business practice, but compliance with this new legislation maybe become an expectation within various supply chains, especially if an organisation within that supply chain are caught under the legislation, and of course could save an organisation from significant reputational damage. So moving on please to the nature of this section 199 offence. So under the section 199 offence, an organisation may be criminally liable where an employee, agent, subsidiary or other associated person who provides service for or on behalf of the organisation commits a fraud intending to benefit that organisation, and the organisation did not have a reasonable fraud prevention procedures in place. In certain circumstances, the offence will also apply where the fraud offence is committed with the intention of benefiting a client of the organisation rather than the organisation itself. So notably, it does not need to be demonstrated that directors or senior managers had involvement in or indeed knew about the fraud in order for an organisation to be held guilty of the offence. It is important to note that the offence will not extend to individual liability for persons within the organisation who may have failed to prevent the fraudulent behaviour, but this does not preclude the employee or agent who committed what's going to be known as the base fraud, or anyone who encouraged or assisted them from being prosecuted for that fraud, in addition to the corporate for being prosecuted to failing to prevent it. So what kind of or types of fraud are covered by the offence? So an organisation can be prosecuted if an associated person's conduct constitutes what's referred to, as I've just mentioned, a base fraud act. Base fraud according to the Act. So it's a type of fraud that's listed in Schedule 13, which includes offences under the Fraud Act 2006. So that's frauds by false representation, by failing to disclose, fraud by abusive position or obtaining services dishonestly, but also under other legislation such as false accounting under the Theft Act or fraudulent trading under the Companies Act. But what does it mean by intending to benefit? So the important question here when considering whether an organisation is found guilty of the offence is who was the fraud intending to benefit? The government guidance makes the point that an organisation may still be found accountable for failing to prevent fraud, even if they've not received the benefit of the fraudulent action. And it will be enough to show that the organisation was simply intended to receive the benefit of the fraud. So the guidance also goes on to state that an organisation benefiting from the fraud does not need to be the main motivation for the fraud being perpetrated. So it's also important to appreciate that the benefit may be financial or non-financial. The example given by the guidance is that a fraud that disadvantaged a competitor would fall within the remit of the offence, as would a fraud intending to confer an unfair business advantage. So that's in keeping with the various types of fraud that I referenced earlier in Schedule 13. But it is important to note that if an organisation is a victim or an intended victim of a fraud that was intended to benefit the organisation's clients, then they will not be held liable for the offence. That being said, an organisation cannot claim that the consequence of being charged with the offence of failure to prevent fraud constitutes being a victim of it itself.
Thank you, Sarah. So moving on, one of the themes which Sarah touched on in her very helpful summary of just what the Section 199 offence consists of was the idea of an associated person. So one of the concepts which lies behind the Act is the idea of imposing responsibility on organisations for what those outside the organisation do. This isn't entirely a new concept. If you look at the Bribery Act, for example, you have similar ideas there. So a relevant body, which is a large organisation, is covered under the Act, but also someone who is associated with the organisation. And that can include not only employees, but also agents, a subsidiary, or someone who performs services for and on behalf of the organisation. Now, the Act specifically mentions supply chains and franchisees, and explains that just because you're in a supply chain or that you are a franchisee, that does not trigger automatic liability on the part of the associated organisation. But nevertheless, you would still have to look at whether that role involves performing services for and on behalf of the organisation. So in effect, organisations are put in quite an unusual situation, which is they may potentially face a criminal conviction for something which is done, which they have no knowledge of, and which was carried out in the hands of individuals entirely outside of their own organisation. I think the other thing which is also worth bearing in mind is, as you can see, what the Act does is it sets up this potential web of parties that an organisation is responsible for. And I suspect that what may well happen is that organisations will try to protect themselves by inserting contractual provisions into their own contract relationships with those they work with, joint venture partners, agencies, and so on, imposing on them an obligation to have in place reasonable fraud prevention procedures. And what that means is that even if you do not come within the strict definition of large organisation within the scope of the Act, you may nevertheless find that you have a contractual obligation imposed on you because some of the people you're working with who are exposed have imposed that contractual obligation on you. So quite an onerous requirement, and it does obviously require some thought to make sure as an organisation that you comply with what is expected of you. So perhaps we can move on and look at compliance in a little bit more detail. Section 199 is a strict liability offence. So what that means is if you come within the ambit of what is set out there, you are liable as a corporate defendant, regardless of whether you were negligent, regardless of whether you had any idea of what was going on, regardless of whether senior management or the board knew what was happening. Nothing has to be proved beyond reasonable doubt. In effect, if you come within the situation set out in the Act, the onus is really on you to show that you had reasonable prevention procedures in place. Now, strictly speaking, there are two ways of establishing a defence. You can either defend yourself by showing that reasonable prevention procedures were in place, or alternatively, you can argue that it was not reasonable in all the circumstances to expect the organisation to have any prevention procedures in place. Now, that second way of escaping liability, we will have to see what the courts make of that. If you look at the comparable legislation around bribery, if you look at the Bribery Act, that did not have a similar let out. The Bribery Act simply says that you have to have adequate procedures in place. There is no express statutory recognition there that it's reasonable not to have any prevention procedures at all. And indeed, in the early days of the Bribery Act, there was an early prosecution where a small company tried to defend itself by arguing that it was reasonable not to have any prevention procedures in place at all, by arguing that it was a small organisation. The relevant key management team had a set of desks in one open plan area, all very close to each other. Everybody knew what everyone was doing. Everybody knew that bribery wasn't permitted. You just didn't need to have prevention procedures. The court actually gave the defendant short shrift in that case. The defence didn't work. It remains to be seen whether the acknowledgement that potentially it's reasonable not to have any prevention procedures in place makes a difference in court. My own instinct is to be very cautious over that. I think the safe assumption is to assume that you need to have some sort of prevention procedures in place, and our recommendation is that you should take steps to put such procedures in place. So perhaps we can move on. We are now going to ask you to answer another question for us, and the question is: does your organisation already have anti-fraud policies in place? Now, as Sarah has explained, you have until the 1st of September this year to put these policies in place. On the other hand, the legislation we're talking about here has been around since the end of 2023, although the implementation date was only recently publicly announced. But nevertheless, it would just be an interesting opportunity for us to find out who has policies in place and who doesn't. And very impressively, the majority of you do already have anti-fraud policies in place. So 66% do have such policies in place, 34% don't. So interesting. So clearly this is already generating some prevention measures, although I suppose one might say that the people who've taken the trouble to log on to a presentation like this are arguably the good guys and the top performers in terms of paying attention to this legislation. Now, as Sarah mentioned, the Home Office published some guidance in November 2024 on what the prevention procedures should look like. I would suggest that it is very worthwhile for people to print off this guidance and read it when a court is deciding what reasonable prevention procedures consist of. I think it's inevitable that they will pay close attention to the Home Office's own guidance in this area. And so it is worth reading the guidance in full, but essentially it outlines 6 key principles which it recommends organisations should follow. And those of you who are familiar with the Bribery Act and other similar legislation will probably recognise these 6 principles as being exactly the same principles which are in the guidance published on compliance with the Bribery Act. So going through the guidance, number 1, top level commitment. So what the government is looking for is for organisations to lead from the top. This isn't something to just be delegated down to a very junior level. I would suggest that it's appropriate for an organisation to appoint a relatively senior individual to take responsibility for compliance with the Act. I would also suggest that it makes sense to have a high-level policy which is published in an appropriate place, stating the commitment of the organisation to anti-fraud measures. The second theme in the government guidance is risk assessment. So what the government really emphasises is that you have to calibrate the risks and design your anti-fraud policy in the light of looking at your own organisation and how it operates. So you really need to carry out a risk assessment. You need to identify where particular risks are. So, for example, are there particular units or teams within the organisation which are more at risk? For example, do you need to have a closer risk at a finance team or an accounts team or a team dealing with issuing invoices than other teams? Similarly, it may be relevant to look at individuals who have very high bonuses riding on particular sales indicators and so on. These sorts of issues may feed into the process of identifying where risks lie. The third principle is to develop proportionate risk-based prevention procedures. So proportion is already baked in to some extent, in that, strictly speaking, the Act only applies to large organisations. But even beyond that, I think the government would recognise that size of organisation is going to be relevant in terms of looking at what is expected by way of fraud prevention. And I think it's also relevant to look at the nature of the organisation. To what extent is this an organisation that, because of what it does or where it works, runs a high risk of fraud, and the prevention procedures you develop should take that into account. The fourth principle is due diligence. So this would include having a proper look at those you work with, so doing proper checks of those you employ, and continuing to do checks after you've employed them, and also having a careful look at other organisations you work with, agents, joint venture partners. You really need to take some basic steps to investigate and make inquiries about who you're working with. Principle 5 is communication. So it's not enough to have all these marvelous anti-fraud prevention procedures, you also need to make sure that not only your own staff, but other organisations you work with are aware of what these policies are. And that would obviously include training. And then the final principle is monitoring and review. So this is not an exercise where you say to yourself, there's some new legislation coming in, let's draft some policies and procedures, make sure we're compliant, and then we can sit back. You really need to continue to review your procedures. I would suggest that ideally you should be reviewing them once a year, perhaps once every 2 years. And there may be circumstances that change in your organisation which also trigger a review. So, for example, you merge with another organisation, you acquire somebody. They are the sorts of situations where you should probably be reviewing your procedures. So that's the guidance. So moving on, we thought it might be helpful just to stick down 1 or 2 key actions which perhaps organizations could look at taking. And certainly FSP has helped organizations work on some of these issues if that's ever of interest to anyone. So I think the first key action is to put someone in charge. Logically, I think the second step is to do a risk assessment, because other actions then flow from that. We would recommend that you have an anti-fraud policy. We would recommend that you take the opportunity to perhaps review your other policies as well. Obviously, there is an overlap between fraud, bribery, making sure you don't facilitate tax evasion, modern slavery. You probably have several policies which to some extent overlap, and it's probably worth having a look at how they relate to each other. So, for example, if you have a whistleblowing hotline of some sort, you're not going to want 5 or 6 different hotlines. You probably want to have a unified approach. You probably ought to carry out a contract review. It may help you to have particular clauses in your contracts covering off fraud prevention procedures, and potentially, as we discussed earlier, imposing contractual obligations on others you work with. And finally, we would recommend that you look at training, not necessarily your whole workforce, but certainly key individuals, maybe accounts teams, sales teams, senior management teams. So that's prevention. What are the consequences for a company if they get it wrong? Well, obviously you could face a criminal conviction and a fine. At the moment, the fines are unlimited. There is no real guidance that I'm aware of at the moment as to the level of fine for this particular offence, but I think inevitably size and turnover of the organisation will be taken into account, and I think fines could be quite substantial. But as well as the literal criminal consequences, there is a whole list of other bad things that can flow from getting caught out in this way. You obviously run the risk of adverse publicity, reputation damage, defence and investigation costs can be quite substantial. If you start having to employ lawyers to look at all this and trawl through documents, this could be quite expensive, and indeed you may find yourself liable for some of the prosecution costs. Management time inevitably is likely to be quite substantial, and that could obviously be quite senior management time. And another final consequence that I also wanted to just touch on is the risk that you could be excluded from public contracts and tenders. Now, at the moment, the Act or a conviction under the Act does not trigger a mandatory exclusion from public tenders in the same way that a conviction under the Bribery Act does. But nevertheless, as some of you may be aware, there's also a discretionary exclusion if there is wrongful conduct which impacts on the professional integrity of the supplier. So I think even with this particular Act, there is still a risk of exclusion from a public contract or tender. Now, some of you may be aware that with some of the prosecutions under the Bribery Act in particular, one way in which large organisations have tried to bypass the risk of finding themselves excluded from public contracts is to enter into something called a deferred prosecution agreement. And the Serious Fraud Office, the SFO, has entered into several of these agreements where basically you cooperate with the prosecutors. There is a deferred prosecution agreement, meaning provided you comply and pay a fairly hefty fine, there is no immediate criminal conviction, and that can be quite an effective way of avoiding some of these consequences, although to take advantage of that, you really need to cooperate with the prosecution at a very early stage. It may be relevant to mention here that I think the Serious Fraud Office has issued some new guidance only this month on this, where they set out what it is they expect from organisations to take advantage of this measure. So that is non-compliance. So if we can move on, I said that there would be an opportunity for people to answer questions, and I can see we've still got a little bit of time left to answer questions. Hopefully various people have been typing away with questions as we've been speaking. Sarah, your eyesight's probably better than mine. Can you see?
Absolutely, yes.
Can you see if any have come through?
We've got a couple. So first question then, if we have proper procedure in place, is that enough? Are we also responsible for compliance?
Right, so what is it that you are expected to do? Obviously, the relevant defence here is showing that you have proper prevention procedures in place. So in principle, provided those prevention procedures are in place, you should be protected. But of course, one of the elements mentioned in the guidance is communication. So you do have to make sure that your employees and those you work with, properly understand what the relevant procedures are. Now, it may just be worth mentioning in this context that if you look at some of the prosecutions under the Bribery Act, there were some very large organisations, Rolls-Royce springs to mind, who had to enter into deferred prosecution agreements to avoid the failure to prevent bribery offence as well as other offences. Now, the funny thing about Rolls-Royce was their anti-bribery procedures were absolutely fantastic. If you looked at their policies, if you looked at all their manuals and guidance, they had the most amazing anti-bribery procedures. But the trouble was, in practice, no one was following them, and some quite senior, certainly middle managers, were sort of running around paying enormous bribes to secure contracts. So I think you have to approach this fairly carefully. So the short answer is yes, just having procedures in place should be enough. But if it's just window dressing, that may not necessarily be enough.
Okay, so I'm going to move on to the next question. So got another one here. Does the government guidance give any more specific example or scenarios of companies failing to prevent fraud? Yes, they do actually. I think it's quite helpful, not only as sort of practical guidance, but it also kind of illustrates the sort of thing that companies ought to be looking out for and the kind of things that the legislation, I think, is going to be envisaging. So just a few, because there's only a few at the moment, but they give an example of the payroll team arranging for some pension payments to be diverted to another project within the company. There's an example given of the accounting department being involved in fraudulent misrepresentation and valuing the company. And also, interestingly, and this sort of goes back to what I was talking about when we were sort of considering who was the fraud intending to benefit, the guidance gives an example of a salesperson who was on commission, who engaged in mis-selling to increase their own commission, but the company still was found in this fictitious scenario given in the guidance, that the company would be found or prosecuted under the Section 199 offence as well, because the benefit was inferred that it would, the benefit would still be inferred on the company, because obviously that increases their sales. So I thought that was quite an interesting one as well, actually, that that the government's obviously thinking about and thinking that this is the sort of thing that companies ought to really be looking out for when they're thinking about the prevention procedures that need to be in place. So yeah, that's the sort of thing that they're talking about at the moment. So let's do another question. We've got a couple here. So we outsource our pre-employment checks. Would this mean we need to review the contract?
Shall I
Sure, yeah.
pick this one up, as I think it comes within the prevention side of things. So the answer to this is absolutely nothing wrong with outsourcing pre-employment checks, and there are all sorts of facilities of various kinds available these days to do checks on either people or organisations. However, it would probably be prudent to just remind yourself of what these checks cover, because I think it is obviously the organisation's responsibility at the end of the day to make sure proper checks are being carried out. Therefore, even if they outsource it, they ought to just inquire, what exactly are these checks? Are they looking at everything we need it to look at? Are they covering all the individuals we need it to look at?
Do we do another question then? Let's have a look. I inferred from your supply chain comments that the size threshold in the legislation are almost irrelevant, as the framework will trickle down. Has anything been said about this by government? So I can say.
Yep, are you happy with that? Yep.
Absolutely. There's nothing that specific at the moment that's been published in the guidance, but I think that's very much, as I think Bill has mentioned quite a few times now, it's very indicative of where we are with the legislation as it currently is. I think that's exactly the sort of thing that's going to come out in time as we see this applied to sort of real life circumstances, and how this sort of just works out in practice. And I think it probably won't take too long for some sort of guidance or comment by a judge or something like that to come out, because I think this is a very practical question, and I think it is going to be very relevant as this comes into effect and various supply chains are affected. So not at the moment, but I think it's certainly a question to watch. I should imagine that it will be picked up and dealt with in some form or another quite soon. I don't know if Bill you agree, but yeah, I think.
Yeah, I think my take on this is obviously the size thresholds are there for a reason. In other words, the government decided when it framed this legislation that it should only apply to large organisations, and as many of you will be aware, there's been a lot of public criticism of, red tape and all the cost of compliance, and that it's an unfair burden for small organisations with fewer resources to bear. So the size thresholds are real. You do have to be careful over supply chains, as we explained, but of course there are many small organizations that just don't work in that sort of context. They work in a way where that issue doesn't apply. Having said that, I think everyone would probably agree that the guidance which has been published represents best practice for any organization of any size, but strictly speaking, legal obligations with regard to it only kick in if you're within the size thresholds.
So I think maybe we've got time for one more.
Yeah, should we make this the last question,
one more.
Sarah?
So,
yeah.
Do we need to have separate policy/guidance on this, or can we include it in our global policy? We are a global firm, and will that suffice the need be seen we are compliant?
So I don't think there is anything wrong necessarily in having a global policy. In other words, the question is, does the large organization have a reasonable anti-fraud procedure in place? If that organization is part of a larger group that works internationally, maybe there are separate legal entities, I don't think there's anything necessarily wrong with having a global policy, provided it's properly reviewed at, say, the UK level in light of the 6 principles and the guidance set out by the Home Office to make sure that it's fit for purpose. So, does it cover all the things that you would expect it to cover? Has it been communicated properly to people in the UK? Have people in the UK been trained? And certainly I would say that probably someone in the UK ought to have UK responsibility perhaps for the global policy, unless it's somebody at the global level who regularly visits the UK and is familiar with the UK operations. So yes and no, I think, is probably the answer on that. So I think we said that would be the last question, and I think we're also almost out of time. We're very grateful to everyone to have attended. We hope you found it helpful. If there are any other questions that come in, we're also happy to answer them by email. And as was mentioned at the beginning, there will be some further information going out. I think I'm right in saying that if you could bear just staying on the webinar for a couple of minutes after the end, I think a feedback poll of some sort comes up. Don't worry if you're keen to rush off and grab your coffee, but if you could give us feedback, that would be appreciated. And on behalf of Sarah and myself, it just remains to thank you for attending and wish you a good rest of your day.
Thank you very much.
Thanks very much. Thank you.